In this interview, I'm going to be talking to Chad Cowie, who is an assistant professor of political science at the University of Toronto. We're going to be talking about Bill C-5, or the One Canadian Economy Act, and some of the implications of it for opposition to projects. Of course, we're talking about pipelines in the context of Energi Media. Welcome to the interview, Chad.
Thank you for having me. I appreciate it.
There has been a lot of talk in the media by the industry about how it wants a number of regulations from the Trudeau area rolled back, and it wants guarantees, essentially, that once a project is approved, that it will get built. And some of them, the comments, have bordered on, in my opinion, oppression of dissent. And, so if you have something like the Wet'suwet'en, who opposed the Coastal GasLink pipeline, you basically, instead of delaying the project, you bulldoze through it and that sort of thing. And I think that's worrying because this is Canada, and we don't do that sort of thing. People are allowed to oppose and dissent. And I just wanted to get your views on how Bill C-5 might affect that.
For sure. Well, there's quite a few things there to look at with how Bill C-5 has gone forward, but the way that Bill C-5 has gone forward is not a new way that bills or legislations have gone through when it has come to inherent rights for Indigenous peoples, especially First Nations people, in regards to territoriality. We have seen this in the case in the past, and this is why some of the Supreme Court cases since 1982 have had to further define and explain when it is okay and when it's not. And of course, when it is okay, it is based on Canada's constitution and Canada's interpretation of what the division of powers is and what its rule of law is. So that's where we get to the point that with Canada, the court has ruled that when it is in Canada's national interest, it therefore has the right to infringe on Indigenous title or Indigenous rights or sovereignties. Wet'suwet'en's a good example of that. What some people don't realize with Wet'suwet'en and the Coastal GasLink was that Wet'suwet'en offered an alternate path for that pipeline. The company said no, and then petitioned and had the government's act on it, which brought in police, which then brought in an injunction and a court case that led to the federal government arguing Canada's national interest is at stake here with this, which then led to the courts approving it and overriding those Indigenous rights. So when we're talking about Bill C-5, it still mimics some of those. And the fact that it only came after it was introduced and implemented, that there was a meeting with chiefs. And again, even with talking about chiefs, we have to be careful with that because these are band council chiefs. They're not necessarily a hereditary structure, and how that works out is quite important. We see some people who are very much in support of resource development talking about the democratically elected people who represent these communities. But there's a lot of questions and a lot more discussion that has to go behind that because they're still only held accountable to the Canadian state because that's what the Indian Act says. So how do hereditary chiefs and how do hereditary structures of government fall into this? Well, and as we saw with Wet'suwet'en, it wasn't so much that the development couldn't happen. It was they offered an alternate route so it didn't impact very important components of their daily life and their connection to their territory. This has traditionally been the case in a lot of negotiations that go on or a lot of discussions that have happened. And this is where this could have continued on and gone down this path of reconciliation and this way of doing consultation that could reflect what is the buzzword now of economic reconciliation, but this is a top-down approach. And we saw that with those meetings where these chiefs go to Gatineau and they're there for a meeting, but they had to provide questions in advance. They had to provide these questions. They couldn't ask things out of line, and it was very much specific to that kind of construct. Unlike today, where we see now the provinces are meeting and it's at a table together and it is actually for dialogue. So we're seeing how it's already kind of steering away from this and following a long line that Canada has followed for development.
I've worked in and around the First Nation world a lot over the last 3 or 4 decades. And one of the messages from the First Nation community, whether it's BC or Saskatchewan or wherever, is before you begin a project, come talk to us. Form a relationship, form a partnership, and then we will go forward with you as partners, and we will be good partners. And we will help you to do these things, but we will have our community's buy-in. And the approach taken by the pipeline companies and by mining companies and others is Aboriginal consultations is a box I have to check. It's in the regulatory process, in the regulatory review. It's a box I have to check, and they usually do a really bad job of it because they just fly in, have some meetings, and think, okay, I've consulted them. Now let's get on with the job. And I thought we were making progress on this, and the industrial community was starting to get it. And this seems to me now we're trying to fast track things. It looks like I worry that we're getting back to the old way of doing things where we're box checking and then steamrolling local opposition.
Pardon me. Um, there seems to be a little bit more of that, but again, that has well, we see some progress, and it looks like that. There's also examples even during the Trudeau government where that wasn't the case. We see this with Muskrat Falls, the dam project in Newfoundland, and how the province and the federal government related to the Inuit who were impacted by that. We see that with Site C in BC, and how the eight communities that were impacted by that development and the consultation, well, out of the eight, six agreed with it and two didn't. The two who didn't agree with it were the ones who were directly impacted by that Site C development. It was their traditional territory as well. And so there's sacred sites and important areas that were being impacted by the flooding. But because majority of the communities said yes, it didn't matter what the two who were going to be most impacted said. And again, we see the same thing with Muskrat Falls. The communities directly impacted by that dam were outweighed by the other ones. And so it was ignored. And again, when we're talking about groups of Indigenous peoples and Indigenous nations, there's many in the area, and the territories sometimes overlap because it's not the same as how we look at territory in the Canadian sense or in the United States or in the UN sense. So there's a lot of that comes in, and so that's still always been an ongoing situation. But a lot of First Nation leaders, whether hereditary or not, whether it's through development or organizations, they do specify that. The key thing that has happened for well over a century is steamrolling and not actually including us when we're supposed to be at the table. That is the traditional part of it. The reliance on Canada's formation in 1867, saying, well, it's either a provincial or federal jurisdiction. We forget that that is also on the factor that it was unilaterally decided that all status Indians are going to be put under the federal government's responsibility and taking that over from Britain. We did not agree to that. No Indigenous nation agreed to that. And there's treaties that talk about how certain things are supposed to be protected. As time goes on, we see the chipping away of some of that autonomy as more stricter laws get put in through the Indian Act, to the point where from, the early 1900s right up to 1950, for status First Nations people, you're being told if you are one of them or not, if you're allowed to live in your community or be a part of it, if you want to go get a job outside of the community, you might lose your identity. If you want to go to school, you're going to lose your identity. If you want to do anything with your land, you have to get permission to do this, and you maybe not even be allowed to, because there's so much strict things in place to prevent that from happening. Because if we're doing that and we're in alongside of it, then there's less autonomy from some of the people who are going to be able to make money. But it also takes away from the province's idea of what their jurisdiction is. And again, court cases have ruled that way. There are many examples, again, though, where First Nations people, Inuit and Métis, have said if we work together on this and we find a more sustainable way that meshes our way of understanding our territory and our way of life with this, because no one thinks that we're all supposed to go back to live in a 1492 perspective unless it's some extreme people on both sides of the discussion. There has to be a way of moving forward. And just like amongst Canadians, there is no one size fits all with thinking and theory and philosophy amongst Indigenous people, not only within the entire Indigenous community, but again, we're also talking about 50 different nations and confederacies that are divided into multiple communities across territory they share with Canada, and that's not including Métis settlements or Inuit settlement or Inuit communities. There's a lot of things that go into this, and there's just a need to figure out how they're doing that. We see examples of how some of that might have been able to be done in territory shared with Quebec by the Inuit and the Cree, and we see that with some of the territory shared by the Nisga'a with BC. But there's a lot of questions about what that means and what that all entails as well.
Okay, with that as background, it seems to me then that if you're going to do as the Bill C-5, the One Canadian Economy Act, envisions, which is basically to compress the time for reviews, that the going back to this old way of making completion of the project the priority and everything else is something to be an issue to be resolved as quickly as possible, or simply to be ignored or suppressed, that's where we seem to be going. And especially if you're talking about a pipeline from Hardisty to Prince Rupert, where we know there's going to be a lot of opposition from local folks and also from activists within the province or just regular folks who disagree. That compression of and the focus on getting things built, your take on that and its potential effect on all of the ability to dissent and the ability to negotiate.
I think a big part of that is because some companies and some people want it done so quickly, and there is a process of having to do this. And again, they're looking at it from federal provincial jurisdictions, and that those pipelines, not just pipelines, but some of these big constructions for natural resource projects or in general, are going to impact multiple nations, not specifically just communities, but multiple nations with multiple treaty areas have different perspectives on their territory. So there has to be, when approaching this, you can't just say, if we're going to, so for instance, if we did build a pipeline all the way to Quebec or to Eastern Canada, that's going to cross more than 30 different traditional territories. That's going to cross multiple number treaties, multiple pre-Confederation treaties, territory that's not even treated. You can't approach it all as a one group. You have to actually approach the things. It's the same thing as if Canada tries to steamroll stuff on the provinces. So, say they want to do something that's going to make all the Western provinces have to fall in line with something. Say, for instance, a carbon tax. And it doesn't go over well because they're treating all the four Western provinces as if they're exactly the same. Well, we know that that's not how the provinces out west look at themselves. It's not how Quebec looks at themselves. Is it really fair for us to simply look at all the provinces as being the same when we know there's a shared identity in those provinces? It's the same thing with Indigenous people. It's not one group. It is multiple nations. And their borders and their traditional territories don't stop at provinces, and some of those treaties don't stop at provincial borders. It continues on into some other areas. And we need to remember that. And in some cases, these groups don't have treaties that have surrendered anything. So there has to be a process for negotiating rather than steamrolling, because the end result is we understand, a lot of First Nations people understand the threats going on from our southern neighbor and from internal structures that are going on that we have to prepare for. It's treating us as part of the team and treating us as part of the discussion and being at the table as equals in order to be able to move forward and do that. And that's part of the process. Instead of looking at First Nations, Inuit, and Métis as an afterthought, which has been a constant situation. And then they're not necessarily listening to us on what can be done in that territory to make it self-sustaining and protecting of the area, and making it so that way the project not only works, but then everyone can at least somewhere be in the middle. And that is usually how Indigenous, for most First Nations especially, that is how you make decisions, make policy, make agreements, do diplomacy, is you find a middle ground where people can at least agree to. It's not one size fits all, and this you have to just simply go by this way or this way. It's being at the table equally and figuring out a way to walk that path forward together, so that way we don't keep making the same repeated mistakes that have been going on over the last century and a half.
Chad, let's wrap up the interview this way. There's been a lot of discussion for years now about what UNDRIP means and the whether free, prior, and informed consent should be required for projects like a pipeline. But then that gets down to the nub of the issue, which is no a veto, and just your take on that and where thinking is within Indigenous communities within Canada at the moment.
I think that depends on a few situations that we have to consider. That's a big question, and how each nation or confederacy or treaty area is going to approach this will be very different. What the relationship in it with the province that they share territory with, or the provinces they share territory with, is going to be a big thing. Does it impact burial grounds? Does it impact very important areas of spiritual importance? Does it impact components that relate to the sustainability of their own lives? Those things come into play here that we have to consider. There are mountains and there are waterways that are considered part of the spirituality of many, many, many nations. And we've seen in the past, such as how Niagara Falls has been treated. That was very important to my people. And a few other locations across territory shared with Canada that are very significant, that have been mined or they have been depleted. And also what happens when we sometimes don't listen to a way to move forward to that. So whether no will be a veto, it also depends on whose definition of free, prior, and free and prior consent, like we're considering here, and duty to consult, because sometimes the example used or the definition that's being used by the federal government does not necessarily reflect what an Indigenous nation's viewpoint is. But on top of that, It's not taking into consideration components of the treaty relationship that we have. And sometimes as well, the province's approach is putting the province first, forgetting how provinces come to exist, which is reliance on those negotiations and those treaties with the crown and with the Canadian government on behalf of the crown. So we see that coming up, especially when we see separatist movements going on. We see that especially in Alberta right now. We see it in Quebec. So there is the potential for it to be able to, but again, we also have to look at and define and read in more fine print what some of these treaties say, because some are more specific, while some aren't. And I would say if they're going to make decisions in, say, Nisga'a territory or James Bay Northern Quebec territory and Ayuichi or Nunavut in territory shared with Quebec, they've pretty much negotiated the ability to say no, and they have to do it. It has to be a tripartite agreement, and there's no reason why we can't consider that way, that as a movement forward in other places, instead of being fearful that it means that we're just going to simply cause problems or prevent anything or demand all the land back.
But isn't the very principle of fast tracking something likely to cause the opposite to happen?
Exactly. Fast tracking it is, especially when, again, there's a history in Canada and even contemporarily a history of this with provinces and with the federal government where they tell Indigenous people, oh, we'll deal with you later. Or going back to a point where we had no legal rights and we had no ability to be represented by council or by political organizations where they just didn't include us at all. We had no choice. They'd up and move us if they wanted to. We see this happen in the prairies a lot. How the railroad gets built across the country, how the St. Lawrence Seaway gets built is a good example of this. There was no consultation. It was just steamrolled through. And from the 60s on, it's we'll deal with you after, we'll talk to you after, we'll include you next time. Each next time, we're not included. So there's a history there that makes it concerning and a reason why we have, well, Canadians might not remember all these examples. We're taught to remember them because how else are we going to make sure things are changed so that way we can actually walk down that path of reconciliation, but also that path towards a future together. We're taught to remember to try to avoid the same mistakes being repeated. Unfortunately, the mistakes keep being repeated. And it's looked at as if we're complaining and we're trying to get a veto and we're trying to do this, but it's the reality of the fact is we've consistently been told we'll include you next time, and next time we're not included. And there has to be a way to be able to move forward that represents both sides. And the TRC talks about this, UNDRIP talks about this, Royal Commission on Aboriginal Peoples in 1996 talked about this. So there are recommendations that are there, and some of these recommendations aren't new and aren't a shock. They've been recommended for 30 to 40 years.
I'm going to sum this up and you tell me whether I've got it or not got it.
No
It's
worries.
so there are all of these there's a long, long history of resource development in this country that's been problematic from the Indigenous community's point of view. And things have changed, but not changed enough. And now that we're talking about compressing time, taking a long process and making it a 2-year process, the danger is that once again, these communities will not, their views will not be taken into account. They will not be partners at the table, and their desires will be suppressed. And I would argue, on top of that, that the views of others, the other non-Indigenous people, the same thing will happen. And that's part of the danger of doing things, of fast tracking things. Have I got that more or less right?
Yeah, no, I would agree with that. Like, because that is pretty much the reality. If you want prosperity and you want to be able to move forward and you want to be able to do all this stuff and see that there are jobs in the future for First Nations people, they also want that. They also want the territory and the land to be there for those future generations to come. Fast tracking it and steamrolling it through isn't going to create that. We've seen that with some projects or why they haven't been created. Doing the proper consultation is an effective way of making those agreements longstanding, and there are companies that have shown that this can be done.
Well, I actually have one more question, Chad. Given all of the conversation that we've had, does the willingness, and I think in the one Canadian Economy Act, this is included, and that is, does Indigenous ownership, an equity stake in these projects, is that enough? And does that satisfy treaty requirements? Does it satisfy legislation? Does it satisfy the desires of the communities if they are in fact sitting on a board and they own a piece of the action?
Again, it will depend on which treaty territory, because again, some are more specific than others. Some is not treated area. So again, we see where these kind of agreements that you're just talking about exist with the Cree in territory shared with Quebec. I believe this is also the case with the Nisga'a, a few things, and with the Dene up north, with their new treaties that they formed with the Canadian state and the provinces or territory that they share jurisdiction with. So there is potential for that. There really is, and we can see how it causes that long-standing relationship where they're included, and so they're having a decision making. They're having a decision play. They're part of the decision making. They're at the decision table. So there is definitely parts of that. There's some places where they don't see the value in that because they've not had to see the value in that because they've been able to just simply steamroll through with trying to push forth quickly. And in some cases for provinces, well, that reflects also how a party stays in government.
Gotcha. Chad, thank you very much. This has been very insightful.
No, thank you very much for having me again. I appreciate it.